Defense lawyer for accused number 5 in the Meyiwa murder trial, Advocate Zandile Mshololo, has argued that Bongani Ntanzi's constitutional rights were not explained to him when he was arrested. Making a submission before the High Court sitting in Pretoria during the murder trial, or the trial within the trial, Mshololo presented a previous judgment to support her argument.
The interviewing police officer is required to record that he has informed the suspect of the allegations, that he is investigating against him, her or her, to ensure that he understands the allegations. There are numerous introductory paragraphs and forms that require completion. The suspect is entitled to make, or if he wishes to do so, whereafter both suspects and the member of the SAPS are required to sign the document. All of the constitutional safeguards provided for in respect of arrest, accused, and detained person are contained herein, and the document sets out each and every step that must be followed in completion. There is no basis in law or fact to conduct any type of an interview or interrogation without completing such a document. Any attempt to do so will render the arrest and detention of the suspect not only unconstitutional but unlawful.
Newzroom Africa's Linda Mnisi is standing by to help us piece together, Linda Mnisi, the pieces of the puzzle that we have seen and heard throughout the course of the day. From what we were able to catch, we caught the rather tense interaction where yesterday Advocate Mshololo requested that the court stands down until today, where she would get a certain document or a certain form. What is that form and why has it caused such a headache today?
Well, the tense moments are in relation to the information that the judge had ordered the state witness, Sergeant Vusimuzi Mogane, to bring to kind of clarify what investigations they were conducting on the 18th of June 2020. If we take a step back, you'll remember that in fact the court heard how but Bongani Ntanzi was taken to the Sibanye Stillwater's mine in Rustenburg after claiming that he was at work on the day that Meyiwa was murdered. Now, to confirm his alibi, the investigating officers, including Mogane, took him to that particular mine where the head of the Human Resources Department basically said that he was not at work. Now, the remaining hours after that particular investigation remained unaccounted for. You'll remember they said on that particular day he was booked out for 18 hours and only brought back to prison the following morning at around 2:30 a.m. in the morning. So he was asked by the lawyer for accused number 1 and 2 what those investigations were for when they were done with confirming the alibi for Bongani Ntanzi, and he indicated that there were investigations that they were carrying out, but due to the sensitivity of those cases, he was unable to divulge that information to the court. The court then ordered that he disclose those investigations that they were conducting, but do it in a form of a note, because that information is sensitive. That note would then be only seen by counsels and the court. But today, the witness, before they continued on arguing around the form that Advocate Mshololo asked for, the witness raising a concern that he saw that confidential information being read by Muzika Sibia as well as the rest of the accused, when the order was that it would not be seen by anybody else but the counsels in the matter as well as the court itself. The court saying that it was very disappointed. The judge, in fact, saying he is very disappointed that senior counsels would behave in this manner. The witness tells the court that those cases are sensitive and they involve, killing of people, kidnappings, as well as threats made to other people. And he was worried essentially about the safety of the witnesses in those cases, because he says some of those cases implicate the accused that are before this court in the Senzo Meyiwa murder trial. So ultimately the judge making an order that the proceedings or the evidence that pertains to those documents be expunged from the proceedings because it has been contaminated, and therefore saying that it will be taking those documents and it will not form part of these proceedings. But after that judgment, you recall Advocate Zandile Mshololo rising to make a submission asking that the court shouldn't be the one that keeps those documents, because they cannot come from the witness and straight to the court. The judge then deciding that, well, he has already made an order, but would not take those documents and keep them. He says, I would not be taking these documents to keep them in my allowance and returning them back to the council. So this pertains to the confidential information that the court had asked for yesterday from this witness, who said he could not divulge information about the investigations that they were conducting on the 18th of June 2020. This is now separate to that document that Advocate Mshololo has been trying to lead in this particular evidence. So the court then now taking a long adjournment, the lunch adjournment, and then will return on what the way forward will be.
Linda Mnisi, thank you very much for putting us in the picture, and the High Court sitting in Pretoria for the Senzo Meyiwa murder trial.